Good morning, everybody. My name's Howard Lederman. I'm from 42 BR Barristers. I'm pleased to be here today with Charles Grossman from Druces, who's a senior associate there and a key collaborator in what we're going to discuss today. Today, we're going to be discussing a case where we worked together as a team to successfully obtain an interim possession order for a commercial landlord. And we're going to show you how this particular kind of remedy throws up some really interesting practical implications. Charles, would you like to say something about yourself and your firm?
Thank you, Howard. Yes, so my name's Charles Grossman, Senior Associate at Druces. We're a city firm, full service. We specialise in litigation, property litigation included, real estate, private wealth and corporate commercial. As Howard's explained, we obtained an interim possession order for a client of ours. It's a very useful tactic and tool to commercial landlords can obtain, because it means that if they have trespassers in their property, they can make an application to courts and get a hearing date within 3 working days. So if you can get an interim possession order, it's very useful indeed. So the story starts, the client gave me a call. Charles, retail tenants in significant rent arrears, please can you get them out for us? This was a very common problem for landlords at the time. After the COVID-19 pandemic, lots of retail units had been closed and rent arrears had accrued. So I advised the client, as I advised to most of my commercial clients when similar problems arise, let's wait for the next rent payment to fall due and then wait for the 21 days stipulated under the lease, and then we'll send the bailiffs in. This then avoids any argument the tenant has that any previous breach of the lease has been waived. So that's what we did. Bailiffs went in, they changed the locks, and that should have been the end of the story. However, lo and behold, a few days later, the landlord was inspecting the property next door, which they also owned by chance. They looked to their right and saw the property was people coming in and out, very, very busy. And as you would say, business as usual. Client gives me a call again, furious, says, Charles, we need to rush off to court now. I had an urgent meeting with the client. I said to them, look, let's take stock. Let's not rush. Going to court's going to cost thousands. Let's wait a few days and send the bailiffs back in. I advise the client to do this because I'm always looking at giving the most practical, pragmatic and cost-effective advice for the client. And my view here was, if we get the bailiffs back in, possibly with some stronger locks, with a shutter engineer, that there is a chance that the tenants won't be able to break back in again for a second time. It's worth trying this strategy before throwing all the money and rushing off to court. So that's what was agreed. Waited a few days. The reason we also waited a few days was because it's a common strategy for tenants and occupiers when they know the landlord is sending the bailiffs rounds, that they stay in the property 24 hours a day. And they do this because they know the bailiffs cannot re-enter the property, because to do so, the property must be vacant. It's known as peaceable re-entry. If the property is not vacant, then it's not peacefully re-entering. So the thinking here was, whilst the tenants or occupiers may sleep there for a few days, eventually they'll get bored and go home to their families, which is precisely what happens. Bailiffs went back in, shutter engineer, stronger locks, boarded up the whole of the property. And we thought surely the tenants won't break back in again. But a couple of hours later, unfortunately, the client's back on the phone to me, Charles, let's go to court. So at this stage, I called Howard and we said, let's have a chat. What's the best strategy here?
So, Charles, at that stage, we weren't sure who had broken back in. We weren't sure if it was the tenant or someone else. So at that stage,
I can stop you there, Howard. Sorry, there's a key point I think it's important to tell everyone in the story. So before breaking number 1 and breaking number 2, I got a call from an individual claiming that he was an assignee. For those of you who don't know, an assignee is an individual or a company that has been effectively sold the leasehold interest. So the previous tenant has sold their interest in the lease to this person. They're the assignee and effectively the new tenant. And he was claiming it was his business and the forfeiture of the lease was impacting him. And it was because of this news that getting the interim possession order seemed very unlikely. Isn't that right, Howard?
That's absolutely right, Charles. So at that stage, if the person in occupation was the assignee or someone on his behalf, an interim possession order wouldn't have been the right thing to do, because he almost certainly would have been let in with the consent of someone who had an immediate right to possession, such as the landlord. So at that stage, we were very uncertain about whether or not an interim possession order was the right thing to do. And we were thinking about whether or not some kind of injunction was appropriate against the assignee or those who were working with him, or whether or not ordinary possession proceedings were the right thing to do. So that's where we were at that stage. As Charles mentions, going in there at night just by changing the locks is risky if someone else is in possession and there's a risk of violence. Then the bailiffs or someone, whoever else you send in, might be committing a criminal offence. So generally speaking, bailiffs won't want to do that. So we had to think about getting some kind of court order. So that's what we were discussing at that stage, Charles. And I think you then went on and thought about it a bit further, didn't you?
Yeah, but it seemed entirely clear that these occupiers were going to keep breaking back in. So we had no choice but to go to court. And as Howard mentions, the two main options at that stage were getting a regular possession order, which unfortunately for the client would probably take 6 months if you're lucky to get a hearing date, not ideal for the client, or applying for an injunction. An injunction would be very expensive and also very difficult to enforce. So it wasn't looking ideal for the client at that stage. But in any event, I emailed the assignee because he mentioned he was abroad and said, please give us your address for service so the court documents can be served on you. It was at this stage we got the smoking gun we were hoping for. He emailed back explaining that it wasn't him who broke back in, but it was his subtenant. So for the first time, he was saying that he had sublet the property to someone else. This was great news for the client because now we knew we could apply for an interim possession order, because as Howard mentions, in order to prevent an interim possession order being made, the occupier needs to show that they had the consent of a party who had an immediate right to possession. And as the assignee didn't have an immediate right to possession because the lease had been forfeited, the subtenant had no basis to be there. So we could rush off to court very quickly and get our interim possession order. So why was this such good news, Howard?
Right. So at this stage, it looked as though the assignee had let a subtenant into possession, and the assignee didn't appear to have the consent, the subtenant didn't appear to have the consent of someone who had an immediate right to possession. So one of the reasons for this was that the lease had been forfeit. So at the time that the assignee let in the lease into the subtenant into occupation, there was no lease. The other reason was that the assignee hadn't registered the lease at the land registry within the required time. The effect of that was that the title to the lease reverted back to the original tenant. So when the assignee had let in subtenant, he had no immediate right to possession. So on the face of it, that appeared to be a good basis for applying for an interim possession order.
So now we knew the IPO was a runner. It was full steam ahead. Quickly drafting the witness statement, getting all the papers ready for court, and finding it at court urgently. And as mentioned at the start, we got a hearing date within 3 working days. The application actually was issued against the assignee, the tenant, and persons unknown. The reason we made the application against persons unknown was because the story kept changing. We didn't actually know who was in the property. We couldn't rely on what the assignee was saying because his story kept changing. He was unreliable as a witness. So we did this so the IPO order would be enforceable against anyone that was in the property. When an application for an IPO is made against persons unknown, there are various hoops which you have to jump through, such as unless the papers are stapled to the property in a transparent envelope, then there is a risk that the IPO won't actually be ordered. there are some and as mentioned, there are some interesting, very strict rules of the court. What's the reason for this, Howard?
Right. So if an interim possession order is made, it's made against trespassers. And one of the conditions of making that order is that the proceedings are served in a way in which they be served against trespassers. And when you serve proceedings against trespassers, you normally make sure that they are attached to the main part of the building, or put someone somewhere at the main part of the building so that they can be easily seen by anyone who attends the building. And that's also, generally speaking, a requirement of an interim possession order, so that anyone who comes along can see quickly and clearly that a court order has been made. So that's the main reason for that. Charles, we went to court, and perhaps you'd like to tell us a bit more about that.
Well, yeah, like I said, we had the hearing date in the diary. 3 working days later, Howard and I, obviously separately, were getting ready for court. I was just about to leave the house when bang, witness statement landed in our inboxes. The assignee had once again changed his story. So what he was now saying was he was back in the property. His subtenancy had quite miraculously been terminated. His subtenant had gone, he was now back in. It appeared to us he was trying to engineer a legal case that because he was now back in possession, the IPO shouldn't be ordered. Howard and I spoke urgently, and we decided, and we knew that the writing was on the wall and the hearing was likely to get adjourned. Do you want to explain why that was?
Yes. So when a court lists a hearing urgently within 3 days of the application being issued, it's under a lot of pressure. The court's under a lot of pressure. And in this case, as in many other cases, the court only allocated 15 minutes for this initial hearing. So it was almost inevitable that this initial hearing was going to be adjourned if the assignee turned up with a lot of evidence, as he did. So this hearing was adjourned so that the issues could be discussed at some length in a hearing that was due to last 2 hours or so. So we got a hearing, I think, in some 2 weeks hence. But that started the ball rolling. So that's where we were after the first hearing, Charles. And then we went to the second hearing. Perhaps you'd like to tell us a bit more about that.
So Howard and I were preparing for the hearing ultimately, and the argument that the assignee was advancing was because the original tenant gave him permission to be in the property, the IPO should not be ordered. Because as Howard mentioned previously, if an occupier has the permission of a party who has an immediate right to possession, i.e. a tenant under a lease, then the IPO can't be awarded. Our argument was going to be at the hearing that whilst there initially was consent from the original tenant for this assignee, even on this assignee's own case, they vacated the property and then re-entered. And at the point of re-entering the property, they no longer had the consent of a person who had a right to possession, because the tenant at that point in time did not have a right to possession because the lease had been forfeited. And ultimately, Howard, the court preferred our arguments, didn't they?
Yes, that's absolutely right. And luckily for us, the original tenant had also fallen out with the assignee. So it was easy to show that when the assignee went back into occupation, having terminated the subtenancy, it was easy for us to show that when the assignee went back into occupation shortly before the second hearing, he didn't have the consent either of the original tenant or anyone else who had an immediate right to possession. And ultimately, that was the basis upon which the court granted the interim possession order. That's the main reason why we were successful at that second hearing.
So it was a great result for the clients. The order was sealed, I think, within a few days. We couldn't enforce it, obviously, until the judge stamped it, put that through in a few days. And the requirement was to serve it 4 o'clock that day. And then the occupiers had to leave within 24 hours. Job done, great result. That wasn't the end of the litigation. There was actually a third hearing in this case. And that was because the interim possession order needed to be made final, and the client landlord also needed to be released from their undertakings. Similar to when you apply for an interim injunction, you have to provide certain undertakings to the courts. Most importantly is the cross undertaking in damages. This is an undertaking which effectively is to the court that if the interim possession order is made wrong for any reason, then the client landlord gives an undertaking to pay the tenant or occupier damages for any losses which they may suffer. These are quite significant undertakings, so the client landlord needed to be released from them at this third hearing. And also they needed to argue for their costs. Very importantly, in all of these types of cases, you need to be asking the court for a cost order. The landlord obtained quite a nice cost order in the region of 40,000, which was another great outcome for the client. So all in all, a great story, but some takeaways to discuss really for commercial landlords who may or may not be in similar situations. I think what this case highlights is it's very important to carry out regular inspections of your commercial properties. If you're a portfolio landlord, then perhaps consider instructing a managing agent to carry out inspections on your behalf, just to ensure you're clear who is in occupation of your property. Also, take very prompt action should a tenant fall into rent arrears. Get in touch with them to see what the problem is, but also get advice before doing so to make sure you don't fall foul of any rules in regards to waiver, because if you waive the right to forfeit, then you can't bring the lease to an end. So these are two very important takeaways. Howard, is there anything else you want to give our audience some advice on?
Yes, so before any commercial lease is granted of non-residential premises, and any landlord should start to think about what happens if there is arrears or if there is an insolvency situation. And two of the things that are often thought about in this situation is whether or not you can have a guarantor or surety, and or whether or not there should be a rent deposit deed. Those things are regularly considered nowadays as right at the beginning, and there's something to think very carefully about when any commercial or any lease of commercial premises is granted.
That's a great point, Howard, because in this particular case, the tenant actually was an insolvent company. So even though we got the cost order and there's significant rent arrears, it was always going to be a challenge to actually get that money back. So at the outset, when you're granting leases, it's very important to consider a guarantor and or rent deposit deed, certainly. I think that's it from us. Thank you very much for listening. If any commercial landlords or tenants out there would like any advice or representation about any of the issues discussed today, please don't hesitate to get in touch with either Howard or I. We work very well as a team, so our details are at the bottom of the video. So thank you very much.
Thanks very much.